Sir, I rise to speak on the Banking Regulation Amendment. I had given a notice opposing the introduction of this bill, and I had also given a statutory resolution against the ordinance. Why I had opposed the introduction? I had said that this is not a necessary bill, nor is there any hurry to issue an ordinance. I shall substantiate my points that I made at that time. Per se, the bill may not be bad, but I'll show that this bill is unnecessary. Under existing laws, the government could have taken steps against NPAs. There is no doubt that the problem of NPA has reached heights from which government will find very difficult to extricate itself. Total stressed assets in gross NPAs and restructure standard advances of scheduled commercial banks was 9.64 lakh crores on 31st December 2016. 9.5 lakh crore se zyada hai. And if you really see the total NPA in financial year 2016 for public sector banks was 9.83% of gross advance, almost 10% of advances in the public sector banks. So measures need to have been taken. But as young member Gaurav Gogoi correctly pointed out, what was the government doing for 3 years as the NPA rose? And these companies, we talk about Vijay Mallya. I will give you the names of 12 top NPA people. Total toxic 12. Yes, very rightly put. Total NPA amount gross is 7.7 lakh crores. What are the big companies? Bhushan Steel, 44,000 crores. One company, 44,000 crores. Lanco, SR Steel, Bhushan Power and Steel, Alok Industries, Amtech Auto, Monet Ispat, Electro Steel Steels, Ira Indro, JP Infratech, ABG Shipyard and Jyoti Structures. The total NPA of just 12 companies is 2,53,729 crores. It is these 12 companies against whom action has been taken under the Insolvency and Bankruptcy Code. But unfortunately, this has the possibility of getting stuck in court because there is already one case in Ahmedabad High Court. So whether this will really sort out the problem, I am not too sure. That's why I am saying that the government had several instruments in his hand. For 3 years, even before this law was enacted, it had both legal and non-legislative loan recovery proceedings. They could have done loan restructuring, corporate debt restructuring, joint lenders forum, 5:25 scheme, strategic debt, sustainable structuring of stressed assets. These were the non-legislative ways open to the banks. Also, the Nishikant ji, there was a case.
Please.
Yes. So you have talked to the Bhushan Steel people.
No.
We'll talk. The other thing is there was already DRT, recovery of debt due to banks and financial institutions. There was the SARFAESI Act, under which asset reconstruction companies could have taken over asset. And then in 2016, we had the Insolvency and Bankruptcy Court. Nishikantji was member of that select committee. Insolvency and Bankruptcy Court is a good law. Now what does this ordinance or the bill, what do they bring into? That the Reserve Bank may issue direction to a bank to go for insolvency proceedings. Now what does the insolvency law say? That you first appoint a insolvency professional. Then he forms a lenders, creditors committee. And then the creditors committee together, they take a decision on the bank. Ultimate arbiter is the National Company Law Tribunal. So this is the procedure, and advantage of insolvency code is that you have to settle the matter within 180 days. So it is time bound resolution of the insolvency problem. But the government did hurry that quickly for these 12 companies whose name Reserve Bank did not disclose. I have got it from the internet. Mr. Premchandran also has. They, against these cases, against these companies, they launched this. Now the main question remains that Reserve Bank, is it an appropriate authority? I am totally against Reserve Bank of recent times, post Raghuram Rajan, because this is the Reserve Bank who up till date have not been able to count the notes which were deposited during demonetization. Why should we have confidence on such a Reserve Bank? Why? The Reserve Bank governor repeatedly in our standing committee we have asked him, why don't you say how much money has come in? My information is they are still counting. They say we have to bring machines from abroad. Totally inefficient, incapable Reserve Bank. Nobody knows how much money has been deposited. And the story of demonetization, the balloon, will be punctured when it is known. Now, sir. Now, what is my... Yes. Sir, listen. Now, bolo.
आउटसोर्सिंग को दिए हैं, वो जरा गिन के देने में जरा लेट हो रहा है. जल्दी आएगा आउटसोर्सिंग से तो हो जाएगा.
No cross.
You are member of the committee. Has the Reserve Bank governor tell us?
Dada, please, chair is here, please. Please.
Sir, I'll wait.
Don't interrupt me, please. Nishikantji, don't interrupt. No, we have not much more time. We have to conclude it early. Okay, Dada, carry on, please. Dada, carry on. And conclude early. What is it you are going on?
Akshul Sahab.
No, it's not good. No, it's not good.
ये दोनों.
Gogai ji, please.
Sir.
Gogai ji, please.
ये दोनों एक्टिव मेंबर है फिनांस स्टैंडिंग कमेटी का, इसलिए एक्साइटेड हो रहा है. लेकिन सर, मैं अभी वाइंड अप करने जा रहा हूँ. आप थोड़ा कृपया कीजिए. मैं तो आपको बहुत अच्छा सपोर्टर हूँ. आप थोड़ा टाइम दीजिए. एक्चुअल फैक्ट मैं बताता हूँ. तो ये सरकार आज बहुत ही खराब मुसीबत में है. द होल बैंकिंग सिस्टम, as our chairman of the committee Virappa Mouli says, is facing a collapse. Government is trying to catch at straws, and one straw is this ordinance. Now, I want to ask various questions that currently under section 35A Reserve Bank may issue directions to banks on grounds of public interest and in the interest of banking policy. Ordinance gives RBI additional power to direct banks to initiate recovery proceedings. Whether the already power of RBI to issue directions is there, why do you need the ordinance then? Second question is, the majority of NPS, 88% of the NPS are in public sector banks. Mind you, the private sector banks, HDFC, ICICI, they do not have such large NPS. So, government could have themselves issued direction. Instead of asking the useless RBI to issue direction, they could have themselves issued the direction, since government owns all this. The government,
Please, what is it going? Please conclude.
Sir, I am concluding.
Please.
Next, my question is, as a banking regulator, RBI is supposed to look after the macroeconomic picture. They, as a regulator, they are responsible for maintaining financial stability, while banks have the flexibility to make business decisions. Say you have to settle a loan, you have to take a haircut. Now, the banks will now not take a decision. They will say that let the RBI tell us, then we'll take a haircut and settle the matter. So the whole, Udai, you agree with me, na? So the whole thing will be delayed.
Conclude, please.
The appropriateness of RBI directing banks on default, which is a business decision, needs to be examined. Why not leave the banks to do their own things?
Please.
The last problem, see, currently banks face certain challenges as part of the recovery proceedings, such as lack of incentives among public sector bankers to recognize losses, 2, fear of investigation in the case of low recoveries, and 3, insufficient capital to absorb losses. Everybody has mentioned that the banks do not have capital. According to Basel III norms, they don't have. So, sir, I am finishing. Last sentence. Last sentence, I have already said that I have given a statutory resolution. I have opposed the introduction of the bill. I have called this an unnecessary bill, and with that, I say that rather I would accept the bill if you accept Supriya Sule's amendment. She has said that the decision of going to the insolvency and bankruptcy board should be left to the banks themselves.
Okay.
Please read Supriya Sule's amendment, accept that, and then I will support the bill.
Speaker Mahoday.